Islam to the Moors.
Islam, nobles.
Islam.
Islam. And Islam.
Yeah, it's good times.
Oh. This is where we're going. I got it. Oh, small space.
We're gonna have to stand in the back.
Is Islam. All rise and stand and remain standing into perpetuity. And according to the ancient Noha laws, as stated in the Holy Congress, this is a sovereign, living, ancient Article 3, Moorish American, Al Moroccan, Universal Court Action, Manawatu Federal Court Action. We are the sovereign, living justices in capita demissia nolo, in red ink, in proprio persona juris, in proprio solo, and in proprio hedis. We are capite et corpus juris legatus, which is our statement that we are the lawful and legal natural head and body for our empire. We are the Bey, Dey, El, Als, and Ali, Moors, the original indigenous sovereign ancient Al-Moroccan, Moorish American ascendants of the great pharaohs of Kemet and of the ancient Moabites and Canaanites. Our full faith and trust, our allegiance, our credit, and our energy are hereby vested in ourselves, for we are the people who are the original indigenous, natural divine, ancient empire state for Morocco, and the de jure Moorish National Republic federal government. We are the ancient Washington District for Columbia and the land for ancient New York. The Universal Moorish American Consulate in the Article 3 Moorish American Consular Court. Today and into perpetuity, we are exercising the law by our sovereign status, which is the original indigenous natural divine sovereign ancient Article 3 living United States New York Republic Court and the Manawatu Federal Court. We are the sovereign fiduciaries, original creditors, executors, trustees, ministers, possessors, and title beneficiary for this cause for action, and all causes for action non pro tunc. Okay? We are peace. We are one nation, one state, one empire, and one God. We hereby recognize ourselves and accept our sovereign ascension. We have issued a universal creditor's affidavit for possession, liquidation, and custody over all land, all resources, both natural and national, all commerce, and all other property. We are the one true God nation. We are the one true God nation. We are the
one true God nation.
And are not at war, and hereby exercise all internal, ancient, original sovereign rights at this time and at all points in time into perpetuity. This affidavit writ for quash termination for all corporate contracts on the land. Notice is to the state. The Supreme Article 3 Council Court Jurisdiction, indigenous, autonomous mound builders for North America people for the land, own the land, and by such virtue are not for sale, nor can it be made for sale for any property, and no corporate contracts, public or private, have any legal standing at law. This order is a cease and desist quash command. Res judica and stare decisis case law. The court case, the United States versus the heirs of Henry Turner, case 32, United States Appellate Court, in 1850 was an appeal to an earlier case won by the heirs of Henry Turner, called the heirs of Turner versus United States, case number 191. In 1848, in other words, on June 6, 1848, a Supreme Court decision read by Theo H. McCallum, judge, declared that the United States does not own the land of ancient mound builders for North America, much more than 1 million square miles. The Moors are the title holders. The titles are El, Bey, Dey, Al, and Ali. translated as the 5 civilized so-called Indian tribes: Choctaw, Washita, Cherokee, Chickasaw, Creek, Muskogee, Seminole, Yamasee. Also, the court declared the lawful landowners are the heirs of Henry Turner, Washita Moors, Mississippi Band of Choctaw Nation. Federal Registry Number 00288088145. Whereas the violation for corporate persons and corporations have been addressed, title, name, and bylaws, etc. That violation is treaties of 1789 and 1836, the Organic Constitution of 1791, and federal laws stated by the living Congress and de jure federal government, non-proton, and international law. The United States Constitution Amendment, Fourth Amendment, the right of the people to be secure in their persons, house, papers, effects, against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describe the place to be searched and the persons or things to be seized. The United States Constitution, Article 6, which you take your oath upon, Clause 2 and Clause 3 of Clause 2. This Constitution, the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or the laws of any state to the contrary are notwithstanding. Clause 3, the senators and the representatives before mentioned and the members of the several state legislatures and all executive and judicial officers, both of the United States and the several states, shall be bound by oath or affirmation to support this Constitution. But no religious test shall be ever required as a qualification by any office or public trust under the United States. Federal Rules of Criminal Procedure Rule 4, arrest warrant or summons or on a complaint form, warrant, a warrant must, D, be signed by a judge. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which abrogate them. Miranda versus Arizona, 384 U.S. 436, page 125. Once challenged, jurisdiction cannot be assumed. It must be proved to exist. Stuck versus Medical Examiners, 94 CA 2nd 751.211 P 2nd 389. Article 21 of the Treaty of Peace and Friendship. If any citizen of the United States shall be killed or wound a Moor, or on the contrary, if a Moor shall be killed or wound a citizen of the United States, the law of the contrary shall take place, and equal justice shall render. The counsel assisting at the trial and shall make counsel shall not be answerable in any manner. If an American citizen in our country and no will shall appear, the counsel shall take possession of his effects. And if there shall be no counsel, the effect shall be deposited in the hands of some person worthy of trust, until the party shall appear, who has the right to demand them. But if the heir to the person deceased to be presented, the property shall be delivered to him without interruptions. And if a will shall appear, the property shall descend agreeable to that will, so soon as the council shall declare the validity thereof. To wit, United States Supreme Court acts for state. Every sovereign state people is bound to respect the independence of every other sovereign state people and the courts of the one country people, and not sit in judgment on acts of government of another done within the same or in its own territory. This firmly establishes a want of jurisdiction on the part of the Union Rights Republic, legally enforced under nation and international law. Whereas cum fire, kum. Be and it is that all Moors are the first and only title holders, lien holders, landholders, and only people who can make lawful title, sell to or for such land, real property, and estate. Article 20 and Article 21 for peace and friendship treaty has been invoked. Whereas the indigenous Ontario's mound builders for North America, the people, are the original title holders, landowners for our estates, hereby first lien holders by virtue, and shall make supreme priority liens hereto the remedy and suit hereby stating claim, redress, remedy for all fraud and treasonous acts carried out by the United States and all ancillary heirs, assigns, agents, principals, and derivatives thereof. Whereas any and all Federal Reserve notes are unlawful debt notes, therefore was never any exchange for any property of any kind at North America. Every exchange is a direct violation of the treaties of 1789 and 1836, the Constitution of 1791, and federal law stated by the living Congress, Manawatu Tribe federal government, and de jure federal government, non-pro-tum. Only gold, silver, and lawful specie certificates are medium of exchange. See the June 27, 1969 case, Jeremy Daly, res judicata case already decided by a district venue. This is lawful notice to agent, is
Lawful notice to principal,
lawful notice to
principal,
principal,
lawful notice to agent.
Islam.
Islam.
Let me get a pen. Autograph this.
Red
Get
pen.
that pen. No, I'll do it with a blue one.